So right now we're getting ready to start the copyright and online courses session with Devin Henson from Midlands Technical College and Tucker Taylor from the University of South Carolina Columbia Library campus. And so you guys can take it away.
All right. Thank you, Veronica, for putting this on. It's been an excellent conference so far. I was there Monday and Tuesday, and both days were excellent. We thought presenting together, it might help, especially the virtual people, a little bit better to actually present virtually, so we could have both of us in a camera shot just as we're talking. So, anyways, good to see everyone today. Today we're going to talk about copyright, and in particular how it relates to online courses. As the years go on, publishers are becoming more and more protective of their materials, especially electronic types of materials. So we just need to be knowledgeable about copyright. I teach an online class as well, so we all need to be knowledgeable about copyright and know what we can and can't use in the online environment. And those sorts of things. So we're going to talk a little bit about that today. Just before we begin, neither Tucky nor myself are attorneys or anything like that. So obviously this is for educational purposes, but don't take anything that we say today as legal advice or anything of that sort. All right, so we'll go and begin and talk a little bit about the definition of copyright.
And hi, I'm Tucker Taylor. I work at the University of South Carolina Library, and one of the things that I do as part of my job is I support online learning by posting course readings online. So I've been butting up with copyright law for about probably 20 years at this point. So I have become quite familiar with it. And as what Devin said, we're not attorneys, but I am a librarian, so I'm happy to point you to lots of good sources of information that you can use to help make your own decisions. So, copyright, many people tell you that the purpose of copyright is to make money, and that is partially true. A lot of people use copyright to make money, but we are fortunate in the United States that we have a constitutional definition of our copyright law, and it explains what the purpose is, and it's to help promote science and the useful arts. So it's to help us progress as a culture, not to lock these works up so that people can make money. And oftentimes that's forgotten. It's important that we provide incentives for creators to create more good works, but as we all know in academia, money's not always the motivation for creating good works. We certainly make no money off of our scholarly articles, but yet we still create them. So there are other motivations in play. But the one that Congress allowed people to have was these monopoly rights so that we can control our works, and hopefully that will give us reasons to keep making more good things.
Hey, Tucker. Your sound is not the greatest.
Okay.
I think if you mute your other two logins that you have, that may help, because you're kind of echoing and then it's kind of drowning you out.
Okay, hang on a second. Actually, I am not up on anything else that I can see.
It looks like you have a mobile device logged in, maybe?
Well, Veronica, that one doesn't have a microphone on. Only the ones with the microphone icon are broadcasting audio.
Okay.
Which is mine and yours, and the one that just says Tucky, which is the one she's broadcasting from.
Okay.
Devin, can you? Okay. Or what? Well, if Devin, do you need to take over? If it's echoing, then you might need to. Better? Devin, can you hear me now?
I can hear you in my office.
Veronica, am I echoing still?
It kind of sounds like you're echoing a little bit.
Okay, Devin, why don't you go ahead and you want to just go for it, and I'll try to
let me. It could be my microphone, because if my microphone's off and Tucky's sound is coming through my mic, I could be causing the echo. Let me mute, or let me turn my sound down and see if that helps.
It's your turn, Devin. We'll go ahead and let you. Oh wait, no, we'll see if that helps. you might be taking over the knowledge of stuff.
Okay. All right. So what we're going to talk about in particular, I mean, we could talk for hours and hours about copyright. There's, a million little nuances that could be discussed when you're talking about copyright. But we want to keep it pertinent for you guys in particular who are teaching in an online environment. So we're going to primarily focus on a handful of things. First off, what is copyrightable? What types of things might have a copyright on them that we would even need to be concerned about copyright? And then once we know what those things are, exactly what rights are granted to somebody. We often say copyright, but does that mean that there's one right, or is it copyrights where there's multiple rights that a person gets? We'll hash that out a little bit, and so we'll have a better idea of what types of rights are granted to a person if they have rights over a particular item. And then lastly, last big thing we'll focus on is just kind of the main focus of why many of us are here today. How do we determine if you can use certain copyrighted materials in your course? As Tucky just said a little while ago, the intent of the law is the furthering of knowledge. That's the main thing, that the main objective, so to speak. And so because of that, there are some exceptions that are carved into the law specifically so that under certain circumstances, we can use certain copyrighted materials in our courses, and we need to know when that's allowed and when it's not allowed.
Okay, Veronica, chime in if I'm echoing. So, one of the things you need to think about is the work you're trying to use covered by copyright law. Now, most things you're going to want to use are. They're written works with a minimal amount of creative expression, things like novels, articles, book chapters, letters, diary entries. Also things like plays and movies, music. All these things are commonly understood to be covered by copyright law. Now, there's some things you may not think about being covered under copyright law. For example, buildings. Buildings are considered to be, since 1992, works of art. And so sometimes things like that will catch you a little off guard, like buildings being covered under copyright law. Certainly the designs of buildings are understandably covered by copyright law, but most people don't think about buildings being covered by copyright law. You can also have multiple copyrights coming into play. For example, in a CD or a iTunes song that you download, you'll have not only the composition, the musical song, whoever wrote the song, but you also have the performer's rights. So sometimes these rights interact in strange ways. Another good example of where these rights can get very complicated is, for example, if I wrote Devin a letter. Devin may own the letter, but he wouldn't be able to publish the letter because I would still own the copyrights to the intellectual property contained in the letter. So even though you can physically own an item, as an archive would or as Devin would if I wrote him a letter, that doesn't necessarily mean that you own the copyright. So they can get a little complicated.
Yeah. Now, one thing that you'll notice that's consistent about all the things that Tucky just mentioned is to get a little bit technical with some wording there. Those are what's known as a fixed tangible medium of expression. So those types of things, as soon as they are in that fixed medium of expression, then they have a copyright automatically. Even a private diary entry. A common misconception is that you have to apply for a copyright, almost like a trademark, and that's not true. As soon as it's in a fixed medium of expression and it has that minimum level of creativity, then it will have a copyright on it. And so now, conversely, here's some things that are not copyrightable. You cannot copyright an idea. Why? Because it's not in a fixed, tangible medium of expression. No one can copyright the concept of capitalism, for example. You can't copyright a fact for the same reason. 2 + 2 = 4. No one can own that, that fact. Processes might be subject to trademarks, but they're not copyrightable. Same thing with phrases and slogans of companies. Those are not copyrightable. Those might be subject to trademark, but not copyright. An interesting one, here's a very strange one. if there's only one way to express whatever that is, it's not able to be copyrighted. And a good example of that is when computers were coming big in 1988. Apple had made their computers, and then Microsoft was on the rise. Microsoft had, in a way, copied a lot of the features that Apple had developed with their computers. For example, the icon of a trash bin, on a desktop. And Apple sued Microsoft in 1988 over copyright infringement. But the courts ruled that there's only really one way you can express the idea of a trash can, and that's a trash can. And so because of that, they were not able to copyright that. So that's a really interesting one. Another interesting one is things that are made by the federal government. If someone in their official capacity who works for the federal government creates a work, that would not be subject to copyright. I actually ran across this one in an interesting place just within the last week. I was doing some training and I needed a picture of some Navy SEALs. And I had pulled up a picture and I was looking for the copyright on it. And I found an interesting note at the bottom that the picture was taken by a sailor. And he was in the course of his normal duties as a federal employee. Therefore, it was not subject to copyright. So that was a really neat find just within the last week or so. The last thing that we'll discuss that's not copyrightable are items that are in what's called the public domain. And we're going to talk about this one more specifically. But things that are in the public domain just simply do not have a copyright attached to them for various reasons. And Tucky's going to talk a little bit more about that in just a little bit.
All right. So most people understand that the right to reproduce something or to copy it is covered under copyright law, but that's not the only right that creators are given. So there are a few other things that are a little less intuitive, and this is one of the things when I first started my journey on copyright that I was a little bit confused about. So it's not only the right to copy, but there's a suite of rights that are given to people who create things. So one of the other things that people get when they create a work is the right to make derivative works. And pretty much all that means is that if you create something from that other work and you take too much of it, then you could potentially be infringing on that person's rights. So for example, if J.K. Rowling creates this character Harry Potter and somebody wants to make a lunchbox with Harry Potter on it, they're going to have to pay J.K. Rowling money in order to use Harry Potter on their lunchbox. So just because she only wrote a book about him and the words are copyrightable, it doesn't mean that the character itself doesn't also belong to her. That's hers too. It's all hers. Everything belongs to J.K. Rowling that has to do with Harry Potter. The right of distribution also belongs to the person who owns the work. So you can't post something online and allow people to download it. One of the things libraries do is we lend books, and there's actually a law in an exception in the law that allows people to lend something once that they've purchased it. Otherwise, libraries wouldn't be able to distribute books. So distribution is also a right of the copyright owner. If you wanted to display something, let's say you bought a work of art and you wanted to put it up on your wall, well, thank goodness there's an exception in the copyright law because the right to display is also part of what is owned by the copyright owner. But you wouldn't, for example, be able to put it up on your web page. So that's another form of display. So, works of art are covered by copyright law. Performance. If you wanted to perform a play, you better be ready to pay somebody for the right to use that play. So, or perform any other type of music work, things like that. So, those are the rights given to people who own the copyright, and they're instilled at the moment that they create them.
Okay, Tucky and I are both going to talk a little bit about the public domain in particular, because this is an interesting one, and if there's anything that's in the public domain, then that's great for us as educators. We can use it unless there's some other entity acting, maybe such as like trademark or something. If there's nothing else coming into play, as long as it's just fully in the public domain, then we can use it fully in our courses. We don't have to ask permission or get licensing fees or things like that if it's in the public domain. So some things that would fall into the public domain, many things that don't have copyrights that we talked about earlier, like facts and ideas and things like that. You can create anything based off of an idea that you want because those particular things do not have a copyright. Governmental works, another example, you can use those as well because they don't have a copyright attached to them. You can assign things. Let's say I wrote a poem or some lyrics to a song, and I really didn't have an emotional attachment to that piece at all or whatever. And I didn't really want to bother either with people asking my permission to use my lyrics or melody or what have you. You can actually assign your work over to the public domain. Now, recently, this is probably becoming a little less common because there's become some better avenues to do that sort of thing. We're going to talk in a little bit about something called Creative Commons that I would encourage you to explore a little bit more. If let's say you're in academia and you've got some works you would like to license other people to use freely, there's some better mechanisms than this probably currently that we'll take a closer look at later. Probably the most common thing people think of, though, when someone says public domain is where the copyright has expired. It's kind of a very nuanced point, but if you remember back on one of the first slides, the U.S. Constitution, when it was talking about the definition of copyright, it said that copyright lasted a limited time. Copyright is not something that once someone writes a book or a poem or whatever, they have the rights to it for eternity. These rights expire, and it all goes back to the original purpose or intent behind copyright. They secure those rights for a period of time to create an economic incentive for them to develop works and whatnot. But because the ultimate purpose is the furthering of knowledge, then at some point, then those rights are going to expire, and then those works fall into the public domain where they're free for everyone to use. The typical public domain timeline is life of the author plus 70 years. That's the way the law currently reads. The U.S. entered into a big international agreement where it's pretty standard among over 100, I think it's 168 countries, where we all have similar copyright laws. And the common consensus is life of the author plus 70 years. So once the author or publisher dies, then add on an additional 70 years from the date of death, and then it will fall into the public domain. If it's a corporation type of deal and it's not like just an individual author, if it's like work for hire or something like that, it'll be 95 years after publication. Or if it's not published, then it's 120 years after creation. Now, those dates can get a little hairy because that's if the work has been published after 1978, I believe it is. So there's a link, and I'll go ahead and reference this. There's going to be a lot of links that we reference, Tucky and I, throughout this discussion. So I'll put a lot of the links over here on the right-hand side. Cornell has a good resource that talks about public domain, and they go through every conceivable situation in regards to dates and copyright and when it was created or published and all those sorts of things. But Tucky, did you want to add anything about public domain?
I wanted to add just a few things, one or two minor things. The treaty that we all entered into actually only obligates us to life of the author plus 50 years. And it's worthy of noting that right now nothing is falling into the public domain, and it's because the United States decided to extend the copyright law beyond that point. There was a law written, I believe it was in 1998, the Semi-Annual Copyright Term Extension Act, and he did more than just single share. He actually increased the term of our copyright law. And right now in Europe and in Canada, works are falling into the public domain every year, but in the United States, nothing's going to fall into the public domain, I believe, until 2019, but it might even be later. Depends on if Disney can pass another law through. But yeah, we're considered to have some pretty restrictive laws when it comes to the length of the term of our copyright internationally. It's also that copyright chart, it's very valuable. It can be very confusing if you have a work between 1923 and 1976 to determine whether it complied with the necessary formalities. Depending on what year it was, there were some things like you had to register the copyrighted work with the Copyright Office, or you had to deposit the work with the Library of Congress, and that chart tells you what you need to think about depending on when it was published and where and those things. It's a very helpful chart.
Yeah, and this in particular is helpful for things that are clearly in the public domain, very, very old works, Elizabethan works and the Mona Lisa and Beethoven, and you can develop course materials based off of these things safely because they're in the public domain. All right, now we're going to move on to a little section where we're going to sit down for a little bit and talk about some teaching exceptions. These are exceptions that are carved into the law intentionally. It wasn't so much of an afterthought. These were because of the purpose of copyright and furthering knowledge. There were these exceptions carved into the law for you and for me as educators to allow us, under certain circumstances, to.
Okay. The first exception that we're going to talk about is fair use. Now, within the copyright law, there are two types of exception. One is very specific, and it's sort of like a checklist. If you meet these criteria, then you're within a safe harbor and you're good to go. Well, fair use is not one of those kinds of exceptions. Fair use is a safety valve that they put into the Title 17 copyright law in the 1976 law. And they realized in 1976 that they weren't going to be able to anticipate every need that we were going to have in the future. And they certainly weren't going to be able to anticipate all the evolving changes that technology was going to give us. So they were smart, and they decided to put this safety valve into the copyright law. Now, one of the important things to realize about this law is that it's a defense. It's not a safe harbor. So if you get pulled into court, you can use fair use to defend yourself. So it's something that you need to think about, and it's probably not something that you can just understand with a 5-minute explanation. You're going to need to do a little bit of study on your own and maybe utilize some of the checklists that other people have developed to help you work through the problems that you have. But we rely heavily, at the University of South Carolina for our electronic reserves, we rely heavily upon fair use. And it's an important safety valve. We wouldn't be able to do news reporting. Copyright law would run afoul of free speech if we didn't have fair use. So again, it's an important law, and people use it every day and don't realize it. But it's 4 factors, and you weigh them and determine whether the balance goes one way or the other way, whether it's for fair use or against fair use. And that's sort of how you make the determination. And I'm going to go through each of the 4 factors, but it's important to keep in mind that even though there are 4 factors, it's not like they all weigh 25% and you come up with an answer at the end. It depends on litigation and the way the courts have interpreted fair use to see if you have a use similar. Right now, we do have a use that's similar for classroom use, posting materials online. It's still evolving. It's going through the courts now, but I'm going to talk a little bit about that when I go through the 4 factors. The first factor is a good one for us. It's the purpose of the work. And nonprofit educational uses usually win this factor. So that's great. Most of us are involved in nonprofit education. If you're at a for-profit, it can get a little murkier. But almost everything that we do with posting things online, we're not doing it for fun. We're doing it in the course of nonprofit educational use. So that's usually good. We usually have a strong win on that factor. Now, another way that we can also win on the first factor, and where it can be, you remember how I said the factors don't necessarily all have to weigh equally? If you have a use where you're criticizing someone, that's almost always going to be a fair use, because that is a highly protected aspect of our way to function as a culture. Americans like to criticize each other, and honestly, it would, back to free speech, we wouldn't be able to have free speech if we weren't allowed to criticize. So criticism is a highly protected fair use, and almost always, so if you wanted to do something like show a film and discuss why this film was terrible and how it did awful things, then you could do that, and criticizing is highly protected. So that's almost always going to be a fair use. So that's the first factor, the purpose of the use. Now the second factor is one that doesn't really matter as much in the course of online teaching as determined by the court case that recently came down. The appellate court, it was a case down at Georgia State University right below us, and it's gone past the district level and it's moved up to the appellant level. We have a ruling back, but they have to go back to the appellant level and reinterpret some of the decisions. back to the district level, so it's sort of bouncing around still, but there was pretty clear direction on the appellate level court that said the second factor is not the most important factor for online posting of course materials. So it's one that whether, goodness, sorry, get all garbled. So if you have a work that is more factual, that's going to have less protection because these works that are factual usually carry less protection from the copyright law. If you have something that's highly creative, it could have more protection. But again, this factor doesn't weigh very heavily for us. One thing you do need to think about, though, is the work unpublished. So if the work is unpublished, it's going to have more protection. If the work has been published, it's going to have less protection. And another aspect of this is it something designed for teaching? So if it's a textbook, that's going to weigh against you. So the nature of the work. Number 3, the amount and substantiality of the portion used. This seems like it would mean that if you use less, then you're better off. Well, that's not always the case. Sometimes you can use the entirety of the work. Sometimes you can use a very small snippet. And really what it matters is, did you use exactly the right amount for what you were trying to do? So if you were trying to show attitudes towards women in the 80s and you were showing a clip from Pretty Woman to illustrate this fact, then you could use a small clip and it would make the same point if you just needed one scene. But if you decided to stream the whole movie, you might have taken too much. So you need to think about what is the exact right amount for what I'm trying to teach, what the point I'm trying to get across, and only take the amount that you need. Now, one of the things that's been floating around is that you can use 10%, or that classroom guidelines say that you can use 1,000 words. There's no basis to any of these in the law. There is no specific amount. People have guidelines like that posted, but there's nothing in the law that states this, and the Georgia State case pretty much struck down any notion that you can give people a clear, bright line guide as to the amount you can use, because every single teaching use is different. And I think that's really what the law says, and it makes sense, but it certainly doesn't help me when I'm trying to make my daily decisions, but again, it gives me the opportunity to argue whatever I'd like. So, and the 4th factor is the market effect. The market effect is not only the effect of the market today, but also if the use were to become widespread, what effect would it have? And where this can get us into trouble is, for example, with the Georgia State case. What they ruled was, if there's a license available for excerpts from these books, then you need to look very carefully and consider whether you need to pay it, because if everybody in academia chose not to pay these licenses, then this could hurt the publishers. So if there's a licensed excerpt available, an excerpt license available for the work that you're trying to use from either the publisher or from another source, then you need to carefully look at that when you're making your determination. But if there's not an excerpt license available for what you want to post online, or if you wanted to post the entirety, which honestly, there are very rare cases where you would be able to post the entirety, I think. But most of the time you're looking for an excerpt license. So you need to think about that. And also with the market effect, I mentioned with the nature of the work that if a work is a textbook, that that could be way against you. It's really the market effect that speaks to that. If you have something created specifically for a teaching market and you decide to use it, most people who do what I do would say that is risky and not a good idea. Textbook publishers and other people who create course content tend to be fairly litigious, and even if they're not, if somebody created something for teaching, you should probably pay them for it if you're using it for the purpose that it was created. So that's sort of how we view that aspect of the law. So you look at these 4 factors and you try to make your best guess as to what you would do when you have your situation in front of you. And it's very good to look at. There's a fair use checklist. There's several, actually. I believe the one that we're linking to is the Columbia one. Is that the one that we're handing out, Devin? Kenny Cruz is sort of the guru with all this. If you want to Google him. He's also got a great book out if anybody was looking for a real more in-depth sort of guide or a reference tool to have when you're looking into these issues. But his name is Kenneth Cruz, and he used to be at Columbia, but he's now in private practice. But that is pretty much fair use. So,
Yeah. Just one little tag on about fair use. Yeah, is just remember that it's a sliding scale. I mean, you can be way on the safe end, or you can be way on the not safe end. but really no one, myself, Tucky, your librarian, really no one's going to be able to give you a definitive rubber stamp yes or no, because of what fair use is. Fair use is an affirmative defense. So the only person who would tell you if it was a fair use or not would be a judge upon rendering of some verdict. So you just want to make sure that you're comfortable with where your use stands on a scale, and on a scale from black to white, based off of these 4 factors. And it's especially with the 4th one. We'll be honest. It's becoming more difficult for educators to make judgment calls, especially librarians, on knowing what the market effect would actually be. I mean, because we're not economists or things like that, but it's still important to know where things are headed legally from these court cases. So speaking of a court case, Tucky, you want to?
This case, was it 2 weeks ago that the ruling came down, Devin? Yeah, and it did you want to cover it?
About 2 weeks ago.
Quiet.
I'll give the highlights, but this is something that Tucky definitely knows a lot about. So I'll give kind of the overview, and then we'll talk about some of the things that came out of this. Georgia State was sued a few years ago by 3 publishers over what they claimed were massive copyright infringements, just sweeping copyright infringements. And it's an interesting backstory, which we won't go into too much detail about, but the lawsuit was funded by an organization called the Copyright Clearance Center. They're an important group to know. They can have advantages and disadvantages. What the Copyright Clearance Center is they partner with license holders and publishers to license educational content. So they're kind of a one-stop shop. You could come to them and get licenses for lots and lots of copyrighted material. But they will also sell you a license, possibly if you don't even need one, and you could use something freely using fair use as well. And so Georgia State kind of bucked that a little bit, and then lo and behold, they got hit with a lawsuit. So there was a ruling that came down from the court case about 2 years ago, and it was highly favorable towards the institution. Big win. There were a lot of claims of copyright infringement. They whittled it down to about 75 that actually the judge ruled on, and 70 of the 75 were deemed fair uses. So Georgia State applied a fair use defense, just like we were talking about, and a big win. The judge ruled that 70 of the 75 were fair uses, and 5 were in fact copyright infringements. Now, the interesting part is that about 2 weeks ago, the process had gone through appeal, and the appellate court just recently, just within the last 2 weeks, as Tucky referenced, the appellate court gave their ruling, and it was not quite so favorable. They overturned the original ruling and remanded it back to the lower court, but with some more specific guidelines. They said that the lower court did not weigh the 4 properties of fair use quite properly. And so it's good in the sense that we're learning more about how the courts rule on fair use through litigation, because that's really the only way the only mechanism by which we have to learn new things about fair use is through court cases like this. So, Tucky, what were some of the interesting outcomes that you noticed from?
For the first factor, the nature of the use, they determined that the lower court had ruled properly, that it was nonprofit education, and that was favored, and so that was a really good aspect of the ruling to be reaffirmed, because even though it seems very obvious to us, that point was actually in contention. They had the lawyers had argued that nonprofit education is not always highly favored, so we were glad to see that upheld. The second factor, the nature of the use, or excuse me, the nature of the work. What is the work that you're using? Is it more creative? Is it unpublished, etc.? They decided that the lower court had not properly analyzed that, but they also said it didn't really matter. So they felt that there was some argument that books that are theoretical could be considered creative, that the theories themselves could be creative, which a lot of people balk at because theories are not copyrightable. So that's a little bit of a worrisome bit to me, because it seems like facts are facts, theories are theories, they're not. They shouldn't be as protected, but that court seemed to think otherwise. The third factor was they found that the lower court did not properly analyze. The lower court sort of gave a 10% guideline, which made sense to nobody who worked with this stuff. It was very confusing for people, the 10% line that they drew. And the appellate court said you've got to go back and look at every single one of these cases and determine, what was that pedagogical need, and where do these two things intersect? Did they use the right amount? Not did they use a specific amount? Because each need is different. And with the fourth factor, it was the most worrisome part for me. With doing what I do is that they determined that with the fourth factor that you needed to look very carefully if there were a license available, which to me means I need to go figure out who owns the copyright, and I either have to pay somebody who likes to sue libraries to negotiate this license for me in a way that will be favorable for the publishers, because that's who pays them, or I'm going to have to track down each individual publisher to find out if they offer a license, and that's worrisome to me. So it was remanded back to the lower court for consideration with this new rubric, and I'm very interested to see what the lower court comes up with as their exact interpretation, particularly when it comes to when is there ever a time when there's an excerpt license available that you can use a work without having to get permission. And I hope that there is. Also, one thing to point out is that these items are these are academic books. We're not talking about journal articles. Journal articles can get messier because it's a much, with a book, the whole book is the copyrighted work, and you're only using a part of it. With a journal article, the analysis would be different because the copyrighted work is the article. So it was interesting for me because it pertains directly to what I do. And I would prefer not to get sued. Or at least I would prefer not to lose a lawsuit.
No, one thing that came out of the court case that maybe, I don't know if it was explicitly stated, but it has to do with the fourth factor, that there's now seems to be a strong encouragement if a license is available for digital content, then we need to start strongly looking at going with the licenses. So that's kind of an indirect thing that came out.
It says it doesn't say that you always, if there's a license available, that it's never fair use. They remanded that back to the lower court, but they said you really need to look hard at whether a license is available as part of this analysis, which to me, it really, now it's just back to the lower court to bounce it back, so we shall see. But it's worrisome to me because I don't want to pay the Copyright Clearance Center because they're suing libraries, and academics, faculty members are being called in to testify in court about what, to justify what they're using to teach. And I don't like any of that. And the Copyright Clearance Center paid for that intentionally as a part of their business tactics. As far as it seems, that's what most people are saying. But so I don't want to pay them, but then it takes a lot of labor to figure out who owns the copyright and then go seek out that publisher. And oftentimes, if you go to the publisher, you can't even get a response. So logistically, it's a nightmare if you're actually trying to do the work. And to expect that of our faculty, I also worry is not necessarily reasonable. There needs to be help and support for that for faculty. If you understand geophysics of the Andes, you really have time to go searching down publishers and figuring out who owns copyrights and stuff. It's a lot of work. This has the potential to become quite an arduous task.
Yeah, absolutely. All right. Okay. Now, I remember there was something I was going to say. Just real quick about this. You hear Tucky and I talking about this, and it sounds very scary. It sounds, I'm not even going to mess with that. I'm either not going to use the resource, or if I use any resource, I'm I'll pay whoever. I'll just pay it. And I mean, and that's an option. I mean, you can do that, but remember that fair use is Tucky and I describe it like a muscle. It's something that we have. It's carved into our Constitution. The idea of copyright, and then we have the fair use doctrine. So we have these things that are legally available to us, and they only remain strong if you continue to use those muscles. So that's what Tucky and I are both pretty adamant of trying to stay knowledgeable, trying to keep up with the court cases and whatnot, instead of just throwing up our hands and saying whatever, we'll just pay for it, to avoid a lawsuit. Because I mean, really, that's one of the things that the Copyright Clearance Center is out to do, is get licensing from people that don't want to be scared or worried about potential litigation or things like that. So it's definitely something to be concerned about, of course. But I would encourage you to think about fair use, learn about.
And there are lots of great resources available, and the checklists are very helpful. But again, just remember, without fair use, we wouldn't have free speech, we wouldn't have freedom of the press, and it's also a very important part of academic freedom.
Okay, now we're going to move into another exception, the second of the two exceptions we're going to talk about. This next one, before we can talk about it, is called the Teach Act. Before we can set that one up, we need to actually set it up a little bit first. Title 17, which covers copyright, Section 110-1, and you don't have to remember all those numbers and everything, but this is the one that you've probably heard of. Maybe you couldn't quote it chapter and verse, but it basically says the performance or display of a work in the course of a face-to-face teaching at a nonprofit educational institution, if you're in a classroom, is not an infringement of copyright. As long as you've properly obtained that resource, this is how you can show movies in class. This is this is what people are relying on in the law. However, for us who teach distance ed, there's something at odds with this in regards to our particular situation, and you notice that it says in a classroom. Distance ed is a little bit of a different animal, so you and I can't really rely on 110-1 because of the virtual nature of our class. Now, fortunately, in 2002, I believe it was, the Teach Act came about, and this was an adaptation specifically made for online courses. So it specifically addresses us. Now, you might say, well, that's perfect. That's us. Let's look at this one. A lot of institutions are not currently using the Teach Act. Most still heavily rely on the Fair Use Act. Mostly because the Teach Act is a little unwieldy, and we're going to talk about the Teach Act here shortly, but I have a suspicion that, especially as court cases come about and fair use is under question a little bit and things like that, schools might look a little bit closer at maybe utilizing the Teach Act for their distance ed classes. The con of it, as I already mentioned, is it's a bit unwieldy. But a benefit of it is it's a checklist. It's a lot of items. It's 20, 30 items or so. But you go through it and you say, we've done this, we've done this, we've done that, we're good here, and you can use it. So in that respect, it can help you sleep a little easier at night, rather than, fair use is gray by the nature of it. It's broad in its definition. So the Teach Act does not supersede fair use, and fair use does not supersede the Teach Act. So they're not at odds with one another or anything like that, but this is specifically designed for distance learning classes. Don't take what I'm going to say in the next 2 minutes as a full understanding of the Teach Act. We're just going to hit the highlights because it's a little unwieldy, but we'll hit the high-level topics. NC State has a Teach Act toolkit on their website. I've got a link in the resources there. It gives you the full checklist and a lot more information than what I'm gonna say here. But we'll at least hit the high-level topics just so you know what the Teach Act is and kind of the main thrust of it. So here's a few highlights. The resource has to be lawfully obtained, which we would hope it would be lawfully obtained anyway. No bootleg copies of this, that, or the other. It has to be a nonprofit educational institution, which is not the case necessarily with fair use. This does have to be a nonprofit educational institution. The materials that you post for your online classes can only be available to the students in your class. This isn't so much of an issue as what it was in the past. Now most people who teach distance ed classes aren't using their personal website. That's what we used to do, 5-10 years ago. Faculty just had a personal website and they dump it on there, and that's the way the online course ran. Many of us now have Blackboard and many other LMSs, Moodle, D2L, things like that. So that helps in that regards, but it has to be limited to your students. One other big item about the Teach Act is it actually has requirements on the instructor and the institution as a whole, which is important to know. So just because you want to use the Teach Act doesn't mean you can run off and use it yet. You actually have to check some things at your institution, such as your college has to have policies about copyright readily available and posted. They have to provide information to faculty and students about copyright law. There's got to be some knowledge, some training given to the college as a whole. In addition to the students in that class, there has to be some notice provided to those students that says, hey, some of the materials in this class might have a copyright, so just be careful. Don't take them and put them on Facebook. Don't do those types of things. And I'm paraphrasing, of course, but there has to be some notice to the students that some of the materials might be subject to copyright in that class. And the main reason a lot of students shy away from, a lot of schools or institutions rather, shy away from the Teach Act is actually the last bullet point. This in my opinion, is probably the most difficult to enact. The college must reasonably prevent further dissemination of those works by students themselves. That's known as downstream control. You don't want to make a conducive environment for further copyright infringement, if that makes sense. And that's difficult to do. If you post a document and a student can download it and then post it, and then that would have been a copyright infringement. That's something you want to stay away from. So what are some ways to combat that? I'll give you an example. If you have a video clip that you're trying to show your students, you could take the video clip and upload it for the students to download and watch. Well, that would make it really easy for them to further disseminate if they've downloaded the video. However, if you're streaming the video, then that is not in a readily transferable format for them. They can't send it on if they're just watching a live stream or a recorded stream there. Now, one thing I do like about the Teach Act is the wording that they use. If you notice, it says reasonably prevent. It doesn't say, no matter what, you have to have complete downstream control. It says reasonably, because even with a streaming video, if a student was technologically astute enough, there are ways to capture video streams, but that's well beyond the technical scope of most students there. So it says reasonably control there. So that's a high level discussion of the Teach Act, but if you want to know more about it, I would encourage you to look at that NC State toolkit for some more information. All right, let's see here. We've got a question from Winona. If you're using Echo 360, students can download the media. If your presentation used copyrighted materials, how do you handle this?
Well, there's going to be, at the end of towards a little further down the presentation, we're going to give you the steps that you have, the questions you have to ask yourself, sort of a flow chart, like to see if you can use something in your class. So this is sort of a similar question, but I can tell you right now that there's no specific exception that's going to allow you to do that. It's more likely than not going to be a fair use decision on each one of those. You also have other options which we will cover later in the presentation about using using Creative Commons licensed materials or getting permission. And ADA compliance, that's also a good question. We might want to hold that one until a little bit later too, but there have been times where there is a section of the copyright law that was designed to harmonize ADA and copyright, but there have been times where I feel like they butt heads and you get to pick which law you want to violate. And I will usually violate copyright law in favor of ADA, but I don't. Devin, did you want to weigh in on that one?
Yeah, we're in agreement there. Yeah, ADA compliancy and copyright law are potentially at odds in some circumstances with one another very clearly. Technically speaking, if you take, let's say, a publisher's PowerPoint was the first thing that popped into my mind, and you want to use that in your course, but you can't because it's not ADA compliant. Technically speaking, by taking their PowerPoint, stripping it down, adding stuff to it, that's a derivative work, right? Because it's not the same work that was originally given to you. But you have to think about and weigh, would that be considered a fair use of that particular work? You could, in those circumstances, contact the publisher and ask if they minded if you modified it to be compliant. They might be appreciative of it becoming compliant, and perhaps maybe even used your tweaks and edits maybe back in an edit of the original version, perhaps. So, you never know until you contact the publisher. But just a completely way side note, from a PR standpoint, it would probably look very bad for a publisher, if you're using a resource that they gave you and you're adapting it to make it ADA compliant, that they sue you for copyright violation. But of course that there's nothing, rock solid there. But
I would think so, and I think that when you're thinking about ADA and fair use and these decisions that you have to make to serve the needs of your students with disabilities, you want to make sure that you're not doing anything sketchy, for lack of a better term. Like if you need to make a scanned copy of a book for a student that needs to use some sort of reader that's helpful to have an electronic copy of that work. You don't want to let that student hang on to that copy longer than they need it. The copy should be destroyed after the class. Things like that. Just make sure that what you're doing is not taking more than you need, particularly because fair use is very dependent upon that. But it's yeah, that's been an area of interest of mine, ADA and copyright and how they butt heads. It's been interesting. So to mention one other thing about the Teach Act quickly is that I don't use the Teach Act in my job, but I do feel that people who want to use video clips or music clips, that Teach Act could be very helpful. And if you have a situation like that, that it's well worth investigating. Oh, so we're getting back to Linda's question now. It's the next slide, so thanks. So if you're trying to make use of a copyrighted material, you need to go through a certain set of questions to see if you can use that material. There's a lot of different aspects of the law and it can get very confusing, so you need to break it down into these 4 steps. So the first thing that you need to do is ask yourself, do I need to worry about copyright law at all? And sometimes you don't. For example, if the work is not copyrighted, if it's something that's in the public domain, if it's a government document, if it's something that was printed in 1850, these things aren't under copyright, so don't worry about it. Also, do you already have permission? And one of the best sources of things that you already have permission to use is your library databases. So if you have a link, and again, I wouldn't download and re-upload, but if you have a link that you can put into your course, we use Blackboard. If you have a link you can put into Blackboard for your class that points to a library database, your institution has already purchased permission for your library to use these materials. So make use of the things that the library has given you. So, and be appreciative of your librarian. But because they've bought a lot of great stuff for you to use in your teaching. So number 1, first, do you already have permission to use it? And number 2, is there already an exception for your use? Well, we're talking about the Teach Act Safe Harbor. If you're talking online teaching, if you're doing face-to-face teaching, there are some exceptions that might be good, but we're talking about online education today. So pretty much you're talking about either the Teach Act or fair use. So you want to see if if you could possibly avail yourself of either one of those. So usually if you have something like a textbook or some sort of course material, or if you wanted to use a lot of a work, you're not going to have an exception under either the Teach Act or fair use. And you have to move on to step 3, and that's asking permission. So again, we talked about the Copyright Clearance Center, and they've taken money for things that are open source licensed or Creative Commons licensed. They've taken money and not returned them to the content owners. I've heard, you hear all these shady things that might be going on with the Copyright Clearance Center and might not. I do know that they seem to be on the side of the publishers as they are funding lawsuits against libraries. So, but then again, we pay them a lot of money because they are fast and they're convenient and they have a good service. So just pick your poison to swallow with that. Seeking permission from the publisher can be complicated. It can just because you don't hear back from a publisher doesn't mean that you can use something. So you can make all sorts of Herculean efforts to contact the copyright owner, and just because they don't reply to your attempts to contact them doesn't mean that you can use their work. So Copyright Clearance Center often has a good solution for that. But, or fourth, different resources. I encourage you that if you find that you want to use a large portion of a work and there are other works available that might meet your need, that you investigate those works or go work with your librarians to see if there's something they can do to help you find an alternate source. So those are the steps that you would go through to see if you can use something in your work. And Winona, let me know if you don't feel like we've adequately answered your question with that. It can get a little weedy, particularly when you're dealing with other students doing these things and you're expecting them to somewhat understand copyright law.
Right. Now, you'll find some people that interchange numbers 2 and 3. They'll say, seek a license first and that sort of thing. But again, it goes back to that flexing your muscle, exercising that fair use muscle. You don't want to pay for something that you have a legal right to use for free. I see that we missed a question earlier. It's my fault. Is it fair to say that you could ask the publisher to make the PowerPoint resource accessible for you? Absolutely, ask them. Yeah, for sure, ask them. I would even, not to diverge off to accessibility, but I would say we need to start demanding our publishers to start making things compliant for us. There's a lot of purchasing power there. If people stop buying, then that dries up. That dries up their market. So I think this is one of those situations where you have to let the dollars, do the talking. And if everyone in academics starts demanding that the Pearsons and Wileys and whatnot start making their resources accessible, then they'll be accessible, even though that's a challenge. All right, couple of supplemental remarks to that last slide. For those of us who teach online, I just want to give a couple of comments regarding some things I've either been asked or had discussions with a lot of faculty about that I thought warranted maybe its own slide. Be careful. I don't want to say don't use. That's not what I'm saying. But be cautious when you're using publishers' materials. As you know, whenever you adopt a textbook, the book reps will load you up with gobs of PowerPoints, digital files, worksheets, videos, etc. Just read through whatever those licensing agreements are for using those resources. There's no way I can tell you what those are without looking at specific examples, but I would encourage you to look through your own. Things you might have to be careful about is if you have some really good PowerPoint resource that goes with a certain lecture, if you no longer use that textbook, are you still licensed to use that PowerPoint even if you adopt a different textbook perhaps? Things like that you have to be careful about. Maybe they intended for you to use it in a face-to-face lecture, but you are not allowed to duplicate it and upload it online perhaps, And I'm just thinking outside of the box here. So just be careful to, if anyone were to ask you how or why are you able to use this resource, that you have a response that you feel comfortable with. That could even be something as simple as an email from the publisher saying, yes, of course, you can use this in your online course. Another thing to be careful about is more and more learning management systems are starting to have repositories, which are basically like a big thumb drive for faculty to upload and share documents with each other. Just be careful there, because if you remember back to this 5 rights that we discussed earlier, the right to display, the right to perform, the right to reproduce, distribute, things like that, you unknowingly could be doing some of those things with copyrighted material by making it available to a wide audience, especially that's not your class. Just putting it in a giant repository like that. So just be cautious about that as well. Another thing faculty ask a lot are about videos on YouTube, and for 2 different reasons. One, they ask, are they freely allowed to use other people's videos if they're posted on YouTube in their course? And then also, are they allowed to, not are they allowed, if they upload their own videos onto YouTube, does YouTube then own the video? And I've heard many things like that. I'll just briefly speak to each of those. As far as using other people's videos, if someone has uploaded a video to YouTube, then they have given the YouTube certain rights. They're in their terms of service, the same terms of service I'm about to reference in the second bullet point there. YouTube has the right to display that work, perform that work, all those types of things that they need to do to naturally do their business. So as long as you're sending people to that YouTube video, or even embedding that YouTube video in your course, you're generally safe, because YouTube has the rights to display that particular work. Now, as far as your own videos, oftentimes faculty are very scared that if they upload it to YouTube, then YouTube owns it and not them, and things like that. I would encourage you to read through YouTube's terms of service. They're pretty short. They're written in plain English. I put the link in the module down there, in the pod down there. And I'm going to summarize here, but read the details for yourself. But basically, YouTube gains a right to do the things you would expect them to be able to do. If you upload a video, obviously they would need the rights to display it. Otherwise, they would be in copyright violation. So they have the rights to display your video, to reproduce your video, to distribute your video, of course, to the world, things of that nature. But now they also say if you were to delete your video or take down your video, then those rights cease. Their rights go away, which is, in my opinion, fair. I don't see how they could do their business requesting anything less than what they've asked. And they say that again the rights go away, and they do say a commercially reasonable time. They don't put like 3 days or 5 days or whatever on it. So that's a minor bit worrisome, but it's not a big scary monster that that you might think it would be. Okay, looks like we have a few questions that popped up. Let me read these real quick. Let's see here. What is this? What about students? My students have to do PowerPoint presentations, and they usually request permission and display the release letters at the end of their.
If they got permission to use the work, then they have permission to use the work, and it's whatever the stipulations the people gave them when they gave them permission. So I guess the answer to your question is, as long as they're doing what they said they would do with the people they asked permission of, then they're fine. I would say that a lot of times with classroom use with students, that they would have good fair use arguments, depending on what they're taking and how much of it they're taking and what they're doing with it. And there's a good code of best practices that speaks tangentially to that. It talks about a lot of other things, but there's a section in the link I put there to the Code of Best Practices for Fair Use for Media Literacy Education. We have a Code of Best Practices for research libraries for fair use, and media educators have also come up with a Code of Best Practices for what they do. And I know that it speaks to classroom use of materials for students in that Code of Best Practices, so I would encourage you to take a look at that resource. The American Center for Social Media, the American Center for Media and Social Impact has a lot of codes of best practices, and sometimes I end up borrowing from all different sorts of them because they have good explanations of different circumstances. And there's a link to their program there. It's sponsored by American University, and they do a lot about fair use, and they put up a lot of really helpful guides for different types of uses. Did you want to add to that, Devin?
Yeah, the only other thing I was going to say is yeah, absolutely. Students have the same rights to fair use arguments that instructors do. So yeah, they can make a fair use argument to use works. In a little bit, we'll talk about rights that students have over their works, and faculty can make fair uses of students' works, and vice versa. So anything in the academic environment, fair use is.
Difficult for somebody to say that an individual student's use in a project could ever potentially become widespread. I think students oftentimes have strong fair use arguments, and it's worthy of looking at that.
Yeah, absolutely. They're taking the class.
Project, they could use a myriad of resources and would rarely pick the same one more than once.
Okay. Okay, I briefly just want to talk about, just lightly skim this and just put it on your radar. We don't want to talk about it too in depth, but in addition to using other people's copyrighted materials, it's also good to know how rights work and who owns certain rights to certain created objects as they're created. If nothing else is in play, if there's no other, nothing else going on, typically the original creator of the work by default owns the rights to that work. If I were to sit down at my kitchen table and write a beautiful poem, then no one but me would obviously have the rights to that. Now, I could transfer those rights to someone else. You can transfer some, or you can even do what's called unbundle. You can even unbundle and give away some of your rights. You can license other people certain rights to where you don't lose the rights, but they gain certain rights for a period of time. An interesting one in the academic realm is work for hire, and it's a real hairy one, so you won't get a rock solid, definitive answer to anything here, but again, I just want to get it on your radar. In certain circumstances, the employer gains a right over a work that an employee creates. You can imagine, hypothetically, if there was maybe like a full-time software developer that worked for Microsoft, and they were developing the next piece of Microsoft software or whatever. It's his full-time job. He's an integral part of the project. Obviously, Microsoft owns the rights over that developer's work in most cases. So in the academic realm, the reason I mention this is it varies institution to institution, and I don't know what USC Aiken's policies are, but it's different across the spectrum. Some institutions are a little stronger on the work for hire language in their policies and procedures. And just the reason I bring that up is, distance ed courses in particular are a lot of work to develop for the faculty and the institution. They both put a lot of blood, sweat, and tears and money and time into developing these courses. Instructional designers, the faculty's time and whatnot. And I would just, I want our faculty to not, and institution, to not be blindsided where someone thinks that they own the rights, either the institution or the faculty, over some piece of work, when in fact it's the other. And those things can be worked out agreeably and fairly as long as they're done transparently. Unfortunately, it's one of those things that don't come onto some people's radar until it's too late. And we don't want to wait until there's an issue. We want to, have discussions and be transparent about that from the beginning. Other people who might own copyrighted materials, heirs. You remember the life of the author plus 70 years. During that period of 70 years, an author could leave the rights to his or her work to his children, so that they could make money off of that book or that piece of artwork or that movie or what have you. And perhaps no one owns a piece of copyrighted, a piece of the copyrights to a particular work because it's in the public domain. So you still have that in play as well. So it's good to know who is owning the rights over certain pieces of work.
Alrighty. So something else you need to think about is that students also have intellectual property rights. Just because they have written something for you that you assign them to do and given it to you doesn't mean, just like with a letter, it doesn't mean that you have the right to post it or to use it in other ways. So anything a student writes, an assignment for you, a play, a journal entry, all these things are covered under copyright law. And even though you can grade them and judge them on it, it doesn't mean that you can reuse it. So where this usually comes into play, I would think, is if, for example, you wanted to take a really good test that somebody did and then distribute it to a class in a future semester so that students can see an example of what a good test looks like. Or a bad test, maybe. I don't know. Maybe if professors are mean, they'll do that. But you need to get permission to do that. And I think that most people, when they think about it, would, we would, just as a matter of what we do, we would ask somebody if they could reuse their work, if we were going to show it to other people, even if we take their name off. But it's good practice to do that, and it is putting you in a better legal position if you do it that way as well. So be careful about redistributing works that other people have done for you, even if they're your students and you ask them to do it.
Yeah, and even if you black their name out, that doesn't really even matter. They still have the rights to that, even if it's anonymous. This one I'm going to skim over. This is one that has concerned me, that came on my radar a few months ago. So just as I talk to different schools, I try to put it on their radar as well. This is a somewhat worrisome website that the way that it functions is students go to this website and they get resources for their courses that they're in, but the resources come from other students who have been in those classes. So the whole premise of the website is that students take faculty's lecture notes, quizzes, tests, PowerPoints, things that are obviously way copyrighted material, and just blatantly upload it. USC Columbia, I was looking at their website. Each department, many departments have almost 1,000 documents, English, history, etc. I put the link to USC Aiken's in there. English faculty at USC Aiken have stuff on there. So I just browsed it yesterday, and it's prevalent. Some of my lecture stuff is on Midlands Technical College's page on their website. So a lot of schools are starting to send this company cease and desist letters. But I just read this morning they got a $15 million investment to ramp up operations. I just read an article just this morning. So this website is growing and is garnering some very large intellectual property right concerns. So just be careful with that, and maybe send a little note to your administration or legal counsel and get some cease and desist letters going to them. So yeah, this is pertinent to us too. In regards to copyright, we need to know what our copyrights are. Couple quick fire things that you may not know about copyright. No longer is it required that you have to post a copyright notice on a piece of material for it to actually have a copyright. As soon as it's in that fixed, tangible medium of expression that we referenced, it has a copyright. Now, if you want to seek legal damages or whatnot, then it will need to be filed with the Copyright Office. But any poem, any diary entry, any novel, any piece of artwork, if you are the creator of it, then it immediately has a copyright attached to it, even without a notice. Same thing goes with websites. If you find something on a website, just because it doesn't say copyright 2014, that doesn't mean it doesn't have a copyright. There is still a copyright on that material, so you have to be careful about what you take. Okay, owning a copy does not mean owning a copyright. You might own the physical copy of the book you bought at the bookstore, but you do not own those 5 rights that we discussed early. What you have is what's known as property rights. You can sell your book, you can burn your book, you can throw it away, you can tear it up. You know, the rights holder can't tell you what you can and can't do with your copy, but you do not have the rights to reproduce it, distribute it, make derivative work, so on and so forth. Another interesting thing you may not know, state agencies like our schools, USC Columbia, USC Aiken, Midlands Tech, or whatever, we have what's called 11th Amendment immunity. And what the 11th Amendment says is it protects state entities from federal prosecution. And copyright would be a federal lawsuit, and we're protected from financial, you know, someone can't come sue you for $1 million. Now you might say, well, wait a minute, Devin, I thought you said Georgia State was getting sued. Well, the interesting thing there is they're seeking injunctive relief, not financial. They're not suing them for money, they're suing them to make them stop. Now it's interesting though, because there is a financial component, because attorneys cost millions of dollars. And so there is a financial aspect to it, but we are protected by the 11th Amendment from Title 17 lawsuits, which is copyright lawsuits. Now, an interesting note, though, is that protection does not extend, that sovereign immunity does not extend to individuals at that college. So the instructor of that class may still be liable, which is a bit scary, but it's just a fact. That's why we wanted to tell you that, is that protection does not extend to individual employees of that institution. It only protects the institution itself. Okay. Another very common misconception is that attribution does not equal fair use. A lot of people think, well, as long as I cite it, or as long as I say where it's from, or say I'm not affiliated with X, Y, or Z, then it's okay to use, which is not true. Citation is a good thing, and it's professional, but it has less to do with copyright law than you probably think. It slightly weighs into a fair use argument because it shows good faith, but by and large, attribution does not weigh too heavily into whether you can use a certain copyrighted material.
Sure. So one of the things that I like.
Okay, Tucky, you want to talk about Creative Commons?
Is that it's very depressing, and it's sort of like, hi, you can't do anything. There's a bunch of doom and gloom. See you later. And it started me really thinking about what else is out there. How can I end these presentations on a less horrible note, where people maybe don't feel quite so despondent. And one of the things that I've come across is the Creative Commons. The Creative Commons was the brainchild of a number of people. I think it started with Lawrence Wesley out in Stanford maybe years ago, and I'm sure a lot of other people. But they thought, if we could allow people to easily put licenses on their work, that instead of put restrictions like most licenses do, you can only use these in certain circumstances if you give me money and safe eat, red shoes, whatever, because usually restrict things. Why don't we create these licenses that put freedoms into your work? So, for example, if you wanted anybody who wanted to use something for an educational purpose or for a nonprofit purpose, as long as they're not making money on it and they give you credit and you're fine with that, why don't you just put a license on that work so that everybody knows it's okay to use your work in that way? And that's what Creative Commons is. And there are a number of different licenses that you can choose from. Some of them say you only have to give them attribution, you only have to give them credit. Some say that you have to give me attribution, but you can't use it commercially and you can't change it in any way. For example, if you're a photographer and you really cared about the composition of that photograph and you were okay with people using it, but you didn't want them to change it, then you could put that license on it. And there are a number of different types of licenses. They're also, for us as educators, or for me as a person who goes out and gives presentations, why should I use a photograph from the web that I stole from somebody who doesn't want me to use it when there are plenty of photographs out there that would also suit my purpose that people put out there for me to freely use as long as I'm not making money. So you can go to the Google Advanced Search and go into licensing and decide, what type of license you're looking for, and Google will help you search. There's also databases that do that for educational tools, and there are lots. This is a completely different talk. But if you're interested in open source material, which is what Creative Commons is one type of open source material, then there are lots of ways to find this material, and instead of using things that have restrictions, use things that have rights attached to them.
Yeah.
Yeah.
Tucky, they were saying your audio was getting a little choppy, so I'll reiterate some of the things that Tucky just said. No, sorry about that. Yeah, Creative Commons is a fantastic tool that I encourage you guys to look into as you develop works and you want people to use your works readily available and freely licensed and whatnot. If you attach a Creative Commons license to it, then you're allowing people to use your work with minimal strings attached. You can make a decision on which Creative Commons you want to attach to it. You don't have to apply, you don't have to upload, you just take it and stick it on your work, and that's it. It can be as simple as attribution, so as long as they say, attribute your work, then they can use that particular work. But they have, attribution, but they can't make money off of it, and things of that nature. So it's kind of a buffet assortment of options that you have. So it's a great tool that I encourage you to look more into. Now, as Tucky was just saying, there are some places that you can go to find some of these Creative Commons licensed images and things of that nature. On Google Images, there's a way to trim that down and search for Creative Commons or freely licensed type of things. But there's also Creative Commons search. You can Google Creative Commons search and you'll find the search box there. Actually, I put a link to Creative Commons down here in the notes pod down there. I use a lot of images for training, and even this particular PowerPoint. And a lot of these came from Creative Commons. Matter of fact, not to digress real quickly here, but for example, this image here came from Creative Commons website, and so you just take the link or the image and upload it, and then it'll put a little attribution that goes there with it. So those are freely licensed. What I would encourage you not to do is do not just go on Google and search images and start grabbing stuff, because almost certainly those will have some sort of copyright attached to them. Okay, before we go to open educational resources, look like we have a couple questions here. Let me read these real quick. It says, when I click on CC for images, it sends me to Google. I'm not clear that all items on Google are available for Creative Commons. Can you clarify? Absolutely, yeah. Not everything on Google Images is Creative Commons licensed. The vast majority is not freely licensed. But if you're referencing Google in particular, there is a place where you can do, I believe it's like an advanced type of search, and search for things that only are copyright free or I don't remember if it's exactly Creative Commons licensed, but I would be probably a little more careful on Google because there are things all around those resources that are heavily copyrighted. I would just make an extra effort to ensure that they are copyright free or freely licensed. Now, the Creative Commons website, you're generally a lot more safe, because that's the whole purpose of the entire site, is to license Creative Commons type of material. Okay, now we want to close with something that we would encourage you guys to look at. Tucky and myself are both becoming more interested in this particular resource, and I think it can solve a lot of our problems. So I would encourage you to do some research on it. These are called open educational resources, and an OER, as it's known, is something that's accessible, modifiable, adaptable, and shareable. a lot of big corporations with lots and lots of money are starting to invest in OERs. Like the Bill and Melinda Gates Foundation is starting to put millions of dollars into this, and they're developing resources that anyone can use. And so unlike publishers' materials who are going to come after you for unfair use of certain materials or whatnot, OERs, on the other hand, are completely free to use. Now, some of them may have some minor costs associated with them, but it's almost always never the $200 for a textbook or something like that. Oftentimes, it's mostly just cost for copying and things of that nature. And usually the PDF type of documents are usually available for free. Now, OERs have been around for quite a while, but the thing is 5-10 years ago, OERs, the quality was very subpar to the premium publishers. And so really no one, including myself, really wanted to use them because, if you have this nice, pristine, book by Pearson or software or something like that, and then you have this primarily text-only, kind of thin, type of Word document created by an instructor or something like that, you would rather, for pedagogical purposes, take the nice, big, shiny object. But the OERs today, that's not the case. These are high-quality, peer-reviewed, very nice resources that are available. And they're adaptable, so if you don't use a certain chapter, you can toss it out. If you want to add in your own material, you can do that as well. And the licensing on these OERs are such that they're conducive to that type of modification. Okay. Some of the good resources to get started with OERs, I put some links down here in the pod at the bottom. OpenStacksCollege.org. OpenStacks is run by Rice University. They've got some fantastic resources. One that's been around a while, my first experience with OERs is MIT OpenCourseWare. They had some money some while back to videotape many of their courses. So like my calculus students, I would supplement some of my instruction with some of their free resources. So they've got a lot of resources as well. So take a look at that. I think we're about out of time, so we'll end it there. We will open up the floor to questions real quick, and if there's no other questions, then we'll wrap it down. But Tucky and I really enjoyed it today. We appreciate you guys having us, and we have thoroughly enjoyed it. Okay, Veronica, any questions there from the audience?
We're good on this end.
Or virtually? Oh yeah, Merlot, absolutely. I should have put Merlot as one of the resources down there. Merlot is a great resource.
We're good on this end, and what I'm going to do is email the chats area and the notes area to myself, and once I compile everything after the conference, those notes will be available for everyone, including the handouts and the links to the recordings.